Hello there, my name is Eli. I'm the host of this show. Today we will talk about working without a contract.
Bitch, better have my money.
Starting work with a new client can be an exciting experience, but what if the relationship goes wrong and the paperwork isn't in order?
Y'all should know me well enough.
What if a client cancelled on you? If you are 3 weeks into a 6-month project, even worse, you'd started work without a signed contract. Ouch, you're bad. Your failure to get a contract signed meant you ended up in county court. Would you win? Do yourself a favor. Don't ever start work without a signed contract. You should have standard business terms and conditions with a letter of engagement. The letter takes about 15 minutes to write up and send. We all have digital tech. They can sign and return immediately if they're desperate for you to start work straight away. You should not pressure to help them out straight away, even if they need to check a couple of things in the T&C. You should learn that if a client is serious about working with you, they'll just sign the documents, yours or their own, so that everyone can start work protected from the outset. First thing to do is send the terms and conditions with a letter of engagement. Even if they don't sign the contract, your client acknowledged they'd received them and read them.
Pay me what you want me.
This means that the judge can take your terms, like your notice clause, into consideration when they'll decide what you was entitled to, because the client was aware of your terms and at no point rejected them or provided alternative ones. If there is no signed contract, or even worse, one was never even provided, your position isn't always clear, but not necessarily weak. If you did work for the client and you can prove that with emails, timesheets, documents, meeting notes, etc., then English contract law may apply. You probably won't have a case if you haven't started work yet, or if they cancelled immediately after requesting some work. What you have to know is that your legal responsibility to mitigate your losses. That means that you can't just ask for the full value of the 6-month contract. You have a duty to replace the lost income. You can only go after the client for actual income loss. How does this work? Again, it's not always clear. This is at the discretion of the judge on the day. First off, get some advice and check your position. Find an independent solicitor and hire him for a few hours only. He will tell you if you are still entitled to make your claim. It is okay to reject the tiny settlement amounts if they offered. If it's a few hundred when a few thousand were owed, he should give you a good steer on the strengths and weaknesses of your case and how a judge might view it. Everything else you should do it by yourself. Prepare documents, create timelines, make duplicate copies of evidence, fill out court documents and pay fees. You should put the case together and there are deadlines to stay on top of too. Be careful about prejudicing yourself. You must use the words "without prejudice" in the email header or body of the letter in any or all negotiations you make with the client. Let's say that you didn't expect that you would end up in the small claims court. Unable to get the client on the phone or in a meeting, you made what you thought was a friendly offer to just pay you for the month and be done with it. Unfortunately, this can be seen as a legal admission that you was only owed for 1 month. You may no longer be able to file a claim for anything more than 1 month's work. It is not unusual to have to get paid out up to 12 months of a service contract, even if only verbally agreed. What should have you done? Well, you must show that, at all times leading up to the case, you acted reasonably. That means considering any offers made to you by the client. For example, you may be claiming $4,000. If the client offers $3,500 and you rejected, this might look bad in court, especially if we're talking about fees and not direct costs incurred. If it gets to claim stage, then the small claims court recommend you manage the whole process yourself and not get lawyers involved. In fact, it can reflect negatively on you if you use a lawyer to prepare the case and/or appear in court. Let's be realistic, lawyers' fees quickly add up to more than the small claim itself. Small claims are any amount under $10,000.
Don't act like you forgot.
As you can see, it's a lot of work. Would you been better writing it off? But if the amount is too big and the impact on you too great to let it go, go for it.
Bitch, better have my money.
For anything less than $1,000 on a consulting gig, I'm personally not sure I'd bother, but you may feel differently. If your claim is successful, you can reclaim court fees, but don't forget that up until the day of the court case, the client can offer you a settlement. Settlements can be less than the amount you're claiming and not include court fees, and of course all the hassle. Don't fall into the trap of pursuing a moral victory either. No court case, successful or not, can guarantee you that. Bye-bye.
Bitch, give me your money. Who y'all think y'all frontin' on? Like